Questions and answers on equity jurisprudence. 1. What is equity? Equity is that portion of natural justice susceptible of judicial enforcement, which was either not recognized at all by the common law, or only inadequately enforced by reason of its cramped procedure. Fetter 1. Equity is that system of justice which was administered by the High Court of Chancery in England in the exercise of its extraordinary jurisdiction. Bispham 1. That portion of remedial justice exclusively exercised by a court of equity is contradistinguished from the portion exclusively administered by a court of common law. Story, Sec. 25. Equality of right, exact justice between contending parties, fairness in determining conflicting claims. Anderson Law Dict. Aristotle has defined it to be the correction of the law wherein it is defective by reason of its universality. 2. Give a short statement of the origin of the courts of equity. Owing to the many technicalities and limited development of the ancient common law, persons whose rights were injuriously affected, frequently failed to obtain relief which was adequate. In such cases the person injured naturally appealed to the king, the highest power, and asked of him substantial justice. These appeals became so numerous that they were entrusted by the king to one of his subordinates, called the Lord Chancellor, and eventually a court was established, presided over by the Lord Chancellor, in which the system of jurisprudence was gradually developed. See Bispham, c. 1, Story, c. 2, Fetter, c. 1. Newlands, Volume I, c. 1, 3. What is the general division of equitable jurisdiction? Equitable titles, equitable rights, equitable remedies. Bispham, p. 28. Discovery, perpetuation of testimony, taking testimony de bene esse, commission to take testimony abroad, where the courts of ordinary jurisdiction cannot enforce a right, where the courts of ordinary jurisdiction cannot administer a right. Adams, fraud, accident or mistake, and trusts. Story. 4. What is discovery? Discovery is that power which was exercised in a court of equity to compel the defendant in a suit, who was not a competent witness at common law, to discover and set forth upon oath every fact and circumstance within his knowledge, information and belief, material to the plaintiff's case. Adams, 1, Fetter, 318, Bispham, 556-565. 5. How is discovery compelled? By the filing of a bill setting forth the facts, and asking that compulsory process issue, under the seal of the court, against the defendant to answer the matters and things set forth in the bill, and the defendant is not entitled to resist this bill except on grounds of general policy. 6. What are the grounds on which a defendant may resist discovery? A man need not discover matters which tend to criminate him, or to expose him to a penalty or forfeiture, need not discover legal advice, need not discover secrets of state, need not discover the proceedings of grand or traverse juries, need not discover communications between himself and his wife, and in certain cases by statute, the statements between doctor and patient, and clergyman and parishioner, need not be discovered. 7. If the bill shows on its face the objectionable nature of the discovery, how is it to be taken advantage of? By demurrer. But if it does not appear on the face of the bill, then the objection must be made by way of plea, or in some cases by answer. 8. The facts are such as to exclude both demurrer and plea. How would you proceed? In such case, the defendant may avail himself of the privilege by answer, provided he states in his answer the fact that he cannot give the information without affording evidence of his crime, or subjecting himself to a penalty or forfeiture, but this rule is subject to modification where fraud is charged. 9. In the case of a penalty or forfeiture to the complainant, who waives his right, can the defendant refuse to answer? Generally speaking, where either by waiver of the party entitled, or because of the passage of time, the penalty or forfeiture would not be enforceable, the answer must be made. 10. How far does the doctrine of non-discovery of legal advice extend? Only to those matters which have been learned by an attorney from his client in his employment as attorney. This is a privilege wholly under the control of the client and one which he may waive, but even after waiver, the attorney cannot be compelled to disclose. It must always be understood that the communications were made to the solicitor in his professional capacity, or that they had reference to the legal proceedings. 11. What do you understand as to the meaning of secret of state? All those matters which are within a person's knowledge because of his official capacity, and which, if stated, might be prejudicial to the community. Marbury vs. Madison, 1 Crunch 144, 12. State the rule respecting discovery. Every competent defendant in equity must answer as to all facts material to the complainant's case. He must answer to all, and not to a portion only, and he must answer distinctly, completely, and without needless prolixity, and to such of his information and belief. This being subject of course to the exceptions as stated in question number 6. 13. Can discovery be compelled as to an incompetent defendant? No. For instance, an infant or a lunatic without a committee, or a married woman where it relates to communications between husband and wife. 14. Is a defendant bound to answer questions of law? No, for such questions ought to be decided by the court, neither need he answer questions of fact unless reasonably material to the plaintiff's case. 15. To what class of jurisdiction of equity does discovery belong? Auxiliary, that is, that it is usually in aid of proceedings in some other court. D. A. Costa vs. Jones, Calp. 729, see also p. 19, Adams. 15. What is the distinction between a bill for discovery and a bill for discovery and relief? Wherever a bill is filed in aid of proceedings before some other tribunal it is called a bill of discovery, but where the bill seeks relief consequent upon the discovery and which is attainable in a court of equity, it is correctly called a bill for discovery and relief. 16. Will the fact that discovery is necessary alter the jurisdiction? No. The equity court will enforce the discovery, but the relief must be sought before that court which has jurisdiction over the matter in controversy. A bill cannot be maintained when filed for discovery and relief where it is insufficient for relief. Preston vs. Smith, 26 Fed. 884. Reddington vs. Lanahan, 59 Mo. 429. 17. Against whom is the discovery obtained by a bill in equity available? Only against the answering defendant unless the co-defendant refers to it by his answer as being correct, or is so connected, by privity, with the answering party as to be bound under the ordinary rules of law by his declarations or admissions. Mills vs. Score, 20 Pick. 34. However the answer, if responsive, may be used as evidence in favor of a CO defendant. 18. Can discovery be compelled from a person who would be a competent witness in the cause? Generally, discovery, when auxiliary, can only be made from those persons who could not testify in the common law court, although it is sometimes compelled from third persons to find who are proper parties to be sued. Storiak, P.L., Sec. 569-570. 19. When may portions of an answer be read? A plaintiff who has replied to an answer may read selected portions of it, but only when the hearing is in equity. If the trial be at law, the whole of it must be taken, just as any other admission. 20. In taxing costs, is there any difference between a bill for discovery and a bill for relief? In the case of a bill for relief the costs are disposed of at the hearing of the cause, while in the bill for discovery the defendant is entitled to his costs as a matter of course immediately upon putting in his full answer, for the reason that the cause is never heard in the equity court. 21. What is a commission to examine witnesses abroad? A person appointed by the court to take testimony of witnesses outside the jurisdiction. In its original it arose from the incapacity of the common law courts to cause a witness, otherwise competent, but who was absent from the jurisdiction, to testify outside the jurisdiction by deposition, without the consent of both parties to the suit. This incapacity has now been generally removed by statute, although the jurisdiction still remains in equity. 22. What is a suit to perpetuate testimony, and when does it arise? It arises when the fact to which the testimony relates cannot be immediately investigated at law, that is, where the person who files the bill has a future interest, or an immediate interest in possession, not actually disturbed, though threatened with a disturbance at a future time. 1 Mad. Ch. Pr. 253. 23. How does the jurisdiction to examine witnesses to beneacy arise? In cases where from the age or illness of a witness, or from his being the only witness to material facts, it is apprehended that the testimony may be lost before the regular opportunity of taking it after the causes at issue has arrived. 24. When can depositions de bene be read? Only where the party who seeks the benefit of them has used all diligence to examine in due course, but there has been a moral impossibility of his so doing. Freer vs. Green, 19 Vs. 320. This bill may also be filed for an auxiliary examination in reference to an action at law, but in such cases, must be supported by an affidavit of necessity. Medford Ch. P.L. 52-150. 25. Can a bill to perpetuate testimony be dismissed for want of prosecution? No. The only order that can be made is to compel the parties to proceed in a given time or pay the costs. Bevan vs. Carpenter, 11 Sim. 22. 26. How did the jurisdiction of equity to grant relief originate? Because of the inadequacy of the remedy at law, which may be said to be because they cannot enforce a right or because they cannot administer a right. Adams. 27. What are the equities under the head of the non-enforcement of rights by the court of ordinary jurisdiction? 1. Performance of trusts and contracts. 2. Election between inconsistent benefits. 3. Completion of gifts or meritorious consideration in favor of the donor's intention after his death. 4. Giving effect to discharges by matter in payes of contracts under seal. 5. Relief against penalties and forfeited mortgages. 6. Re-execution and reformation of instruments which have been lost or erroneously framed. 7. Rescission and cancellation of contractions illegal or fraudulent and which have been carried on in mistake of material fact. 8. Injunction against irreparable tort. Adams. 28. When does the jurisdiction to enforce the performance of a trust arise? Where property has been conferred upon and accepted by one person on the terms of using it for the benefit of another. 29. What is the designation of the parties to a trust? The person to whom the trust is given is called the trustee, and the person who is entitled to the benefit is called the Sestuique trust. 30. What is the principal advantage of a conveyance in trust? It enables the owner of property to effectuate dispositions of a more complex character than could be done at law, and is also a means of protecting incapacitated persons by vesting their property in persons who manage and apply it for their benefit. 31. When a trust is created, what power does the trustee have? At law, he is vested with the complete legal ownership and can and must do all acts in a court of law, the right of the Sestuique trust being only recognized in a court of equity. 32. What two things were essential to the origination of a trust? 1. That the ownership conferred be coupled with a trust, either declared by the parties or arising by presumption of law. 2. That it be accepted on the terms of the trust by the trustee. But in equity a trust will never be allowed to fail for want of a trustee. 33. How must a declaration of trust be evidenced? Independently of the statute of frauds, 29 Car. 2, ch. 3, 1676, sex. 7, 8, 9, no particular method of designation was necessary, but by that statute it was required that trusts of lands should be created in writing, unless they arose by implication of law. See also Hiltrius. 56, Perry Dr. Sec. 78, Mosley vs. Mosley, 86 Alabama 289. 34. If it should appear on the face of the bill that the trust lies in peril, how should it be taken advantage of? Biden-Mera, Barr vs. O'Donnell, 76 California 469. But, if it does not appear on the face of the bill, the statute must be set up by plea or answer. Hill Tr. 61. Further, if the statute be not set up in the pleadings as a defense, it will be deemed to be waived. Carpenter vs. Davis, 76 Ills. 14. 35. Is it necessary that a trust should be declared in writing? No, but only that it shall be manifested and proved by a writing. Perry Dr. Sec. 79, and the cases thereunder cited. 36. If a trust be created by parole, and after its creation a writing is made showing its existence, is that sufficient? Yes, but this depends, however, in each particular jurisdiction upon the wording of the statute, for if the statute states that it should be created and declared in writing, it must be done in that manner. Gaylord vs. Lafayette, 115 Indiana. 423-37. If a trust be created by will, what is requisite as to the instrument? That it should be executed with sufficient formality to be admitted to probate and record. Perry Dr. Sec. 87-38. Does the statute of frauds have any bearing on the creation of a declaration of trust in personal estates? No, it only refers to trusts or confidences in lands, tenements or hereditaments, and a trust of personal estate created by word of mouth, provided there be a certain declaration of that trust, is perfectly valid. 39. An intention to create a trust in realty by writing, or in personalty by parole, must have what requisites? A certain declaration of the property on which the trust is to attach, of the parties to be benefited, of the trustees, and of the interest which the parties to be benefited are to take. 40. If there should be an uncertainty as to the parties who are to be benefited by the trust, what would be the result? A resulting trust in favor of the donor, by operation of law. Brown vs. Coombs, 5 Dutch, 36. Also Smith vs. Brown, 66 Tex. 543-41. Is the certainty of a trust affected by the circumstance that it has been declared in the form of a power? The fact that a trustee is given the discretion to give an estate to the parties named as sestuique trussants, or not, in his discretion, or because of the use of precatory or recommendatory words, does not affect the certainty of the trust, unless the formal language used shows a contrary intention. 42. When does the creation of a trust in the form of a power arise? Wherever there is no positive direction to the trustee, that he shall hold for a given person, but it is left in his discretion as to whether or not they shall take anything, such a power does not necessarily constitute a trust, for a trust may be executed by compulsion against the trustee, while a power cannot. 43. What are precatory words? Such as are used being not mandatory, but merely of recommendation, entreat or desire, and under the old decisions, they created a trust, see in Re Adams and Kensington Vestry, 24 ch. divide. 199. Also, Williams vs. Worthington, 49 MD, 572. But do not generally today. 44. What is a resulting trust? Such a trust arises where the legal ownership of property has been disposed of, but it is apparent from the language of the disposition itself or from the attendant circumstances that the equitable ownership or beneficial interest was intended to go in a different channel, although there is no declaration or no sufficient declaration as to what that channel should be. Adams 31-45. What is the distinction between a resulting trust and a constructive trust? Both are classed under the head of implied trusts. The second arises purely from the construction of equity, and in order to prevent a fraud. 46. Under what circumstances do resulting trusts from the language of the gift occur most frequently? In dispositions by will. But they are not necessarily restricted to such dispositions, for whenever it is apparent that the beneficial interest was not intended to accompany the legal ownership and no other all sufficient is made, then it goes back, results, to the original grantor. 47. As between things real and things personal, is there any difference as to resulting trusts? None whatever as to this class, because there being a failure either totally or partially of the purposes of the gift, the real estate must go to the real representative, and the personal estate to the personal representative by way of a resulting trust. 48. Give an example of a resulting trust arising from the attendant circumstances. These ordinarily arise where one man has furnished the purchase money and an estate has been taken in the name of another. This is only a presumption, however, and may be rebutted by showing the existence of a good consideration between the purchaser and the person who advanced the price. 49. Can a person who has advanced the price of an estate which has been taken in the name of another, show such advancement by parole? Yes, for the reason that trusts of this kind are expressly accepted by the statute of frauds, sec. 8. And this allows parole evidence to be introduced. 50. May the nominal purchaser rebut the presumption of trust? Yes, by showing the intention to give him a beneficial interest, by showing that the purchase money was a loan to himself or by showing the existence of a good consideration.